Very warm good evening to all. As a professional lawyer, we meet so many clients sometimes, and they give us so much information to us, and they expect that this information we do not share with anybody. Now, this is a professional communication between ourselves and our client. Now, what happens if we share this information? We are forced to share this information. The law says you cannot share certain kind of information. I've already dealt with this subject, but today we'll be dealing with it by actually reading the proper sections. And so we understand as a lawyers, it is our duty and responsibility that if there is an information which is given to us by our client, we are not supposed to give it to anybody unless and until we are compelled by law. The law says that you have to give certain information. Simply, we can take an example. Somebody comes to you and tell that I have committed an offense and will you defend me? Now, this is enough. So now if he goes and engages another lawyer and he has already confided with you that I have committed a murder or I have beaten up somebody. Now this information is up to you, and you cannot disclose this information and be a witness in this kind of matter. But suppose a client comes to you and they say I have committed a crime and now I am going to commit another crime. Now, if he has committed a crime, your duty is up to only to that to defend him. But if he is going to commit another crime, then it is your duty as a citizen. That is above the legal. You may be a legal advisor, whatever it is, or a law, or his or her lawyer. There you have to inform the police or the that you cannot, because if you are getting any information about the offense which is to be committed, then it is your duty to inform the police authorities or the concerned authorities that such crime, and it is your duty, that such kind of crime is not committed. Once the crime is committed, your role starts. But if you have any information there is a crime likely to be committed, then it is your duty to stop that, telling your client not to do it. And if he still does it, then you can be a witness to that. So you should be telling the client that don't do it. So as a lawyer, our duty is to stop the clients from committing any crime. If he has committed, then we can defend him to the best of our ability. Still, we are known as the officer of the court. Our first duty is towards the court. Now let's read a few sections from the Evidence Act. Just a minute. I'll be sharing this. Now we will read the first section is 126 professional communication. You will have a clear idea. No barrister, attorney, pleader or vakil shall at any time be permitted unless with his clients express consent to disclose any communication made to him in the course and for the purpose of his employment as such barrister, pleader, attorney or vakil by or on behalf of his client, or to state the contents or condition of any document with which he has become acquainted. There may be any document also in the course and for the purpose of his professional employment, or to disclose any advice given by him to his client in the course and for the purpose of such employment, provided now that nothing essential protect from disclosure. अभी exceptions है. Any such communication made in furtherance of any illegal purpose, आगे का crime commit करने के लिए. Any fact observed by any barrister, pleader, attorney or vakil in the course of his employment as such, showing that any crime or fraud has been committed. Any fact observed by any barrister, pleader, attorney or vakil in the course of his employment as such, showing that any crime or fraud has been committed since the commencement of his employment. It is immaterial whether the attention of such barrister, pleader, attorney or vakil was or was not directed to such fact by or on behalf of his client. Now the explanation, the obligation stated in this section continues after the employment is ceased. Even after you have stopped working for him or her as a lawyer, this will continue. There are some illustration. We'll read it to make you understand better. A client says to B, an attorney, I have committed forgery and I wish you to defend me. As a defense of a man known to be guilty is not a criminal purpose. This communication is protected from disclosure. You need not disclose it because he has told you that I have committed. It is not in furtherance. Now B, a client says to B, an attorney, I wish to obtain possession of property by the use of a forged deed on which I request you to issue. Now see, here it is telling that I wish to obtain. That is in furtherance of the crime. This communication being made in furtherance of a criminal purpose is not protected from disclosure. So always as a lawyer, junior lawyer, you should remember all this. C, A being charged with embezzlement retains B, an attorney, to defend him. In the course of embezzlement, पैसे का ऊपर नीचे करना. Accounting is not done properly. In the course of the proceeding, B observes that an entry has been made in A's account book charging A with the sum paid to have been embezzled, which entry was not in the book at the commencement of his employment. This being a fact observed by in the course of his employment, showing that a fraud has been committed since the commencement of the proceeding, it is not protected from disclosure. Now, after his engagement, after our engagement, the meaning of this section 126, after our engagement as a lawyer, our client cannot commit any crime. If he commits, it is our duty to inform the police authorities. There is one more section, that is 129. This is confidential communication with legal advisors. No one shall be compelled to disclose to the court any now this is a with little elaborate. Any confidential communication which has taken place between him and his legal professional advisor, unless he offers himself as a witness, in which case he may be compelled to disclose any such communication as may appear to the court necessary to be known in order to explain any evidence which he has given, but no others. Now this is little tricky to understand. Now there is a some confidential communication which has been given to us by our client as he has engaged us. Now we are not supposed to give this information to any court, or unless he offers himself a witness, the client himself comes as a witness, in which case he may be compelled to disclose any such communication as may appear to the court necessary to be known in order to explain any evidence which he has given. The client may be offering himself as a witness. In those cases, it is different. But as a legal advisor, you are not supposed to disclose any such information. Now, there is one more communication I would like to share with you. That is 122. Communication during marriage. Now, what happens? The husband and wife, they stay together. There is a possibility the wife may be knowing so many things about the husband. Husband may be knowing so many things about the wife. Can this communication be also privileged communication? Look at this. No person who is or has been married shall be compelled to disclose any communication made to him during marriage by any person whom he is or has been married, nor shall be permitted to disclose any such communication unless the person who made it or is representative in interest consent, except in suits between married persons or proceedings in which one married person is prosecuted for any crime committed against the other. Now see, communication during marriage. Suppose, see, husband and wife's relation is sacred relationship. Now here what happens, that if husband does anything and he comes and tell his wife, who is the life partner, now she is not supposed to say to the police that my husband has committed a crime. This is also as good as the communication between a lawyer and the client. She cannot tell the police, yes, my husband has committed. She is not supposed to tell. She is a wife. It is her sacred duty to protect her husband. Same way, if the wife has committed a crime, the husband is not supposed to go and tell anybody that my wife has committed a crime. But there is one exception to this. If these married persons prosecute each other, suppose there is a 498 case, suppose there is some other case, they have beaten each other. Now, where they are prosecuting each other, in those cases, this communication will not apply. So, section 122 will not apply in such where the wife is prosecuting the husband. There she can tell everything about the crime, which crime, not the one which he has committed, is committed in relation to the married person in respect of the wife, or the husband has committed disrespect of wife, or wife has committed disrespect of the husband. This kind of only the offenses can be disclosed before the court. Otherwise, it cannot be. Again, this will be also privilege communication. So these sections are very important to know each other. As a junior lawyer, we should be knowing this. Now I hand over to Palomi to read. Please unmute yourself.
Yes, ma'am.
Palomi will be reading the Calcutta High Court judgment, Jagat Taran Chakravarti versus the state. It is of 2011. Again, a murder trial. Start reading from here.
From where, ma'am?
Reena Chakravarti, number 2.
Yeah. Okay. Reena Chakrabarti, an educated young housewife, aged 25 years, succumbed to her burn injuries at MR Bangpur Hospital at 11 p.m. on 31/12/99, leaving behind her daughter Romita at Mumbai, aged about 2.5 years. She was married to the appellant on 21st April 1995. It was a love marriage. In November 1998, a maintenance case under Section 125 CRPC was filed against her husband. She had to leave her matrimonial home and to reside at her parental home at 86B Toligang, Kolkata 33 on and from 12th January 1997. The appellant husband began to pay visit
There on the
visit there on the plea to see her ailing father. He used to entreat her to go back to her matrimonial home. On his persuasion, she ultimately returned to her husband's house on 1st November 1999. On 31st December 1999, at about 10:30 a.m., there was a quarrel between the spouses, followed by scuffling over family affairs. During such quarrel, her husband poured kerosene oil on her and ignited a matchstick which was thrown on her sari, which caught fire immediately. She started screaming for help, and her husband started shouting for help, stating that she had set fire to herself. Thereafter, neighbors came and tried to extinguish the fire by pouring water. She was thereafter brought to MR Bangpur Hospital by her husband and one Sinbani Ghosh, PW 14. She was admitted in the said hospital for medical treatment. Her contention as above was recorded by Mr. S. Banerjee, SI of Police attached to Toligang, as a PS PW 22 on 31st December 1999 at 6 p.m. from the hospital bed in the presence of her father, Sanjay K.R. Haldar, since deceased, and Partha Sengupta, a man of the locality, PW1, Dr. Sanjeev K.R. Saha, PW 16, RMO, on duty at the material point of time, assisted the police officer in recording the statement of the victim by making relevant queries to her. Her RTI was also taken by the police officer on the said statement. Such statement was treated as an FIR. Subsequently, the FIR was converted to a dying declaration of the victim on the demise at 11 p.m. on the date of admission. Registration of police cases. The father of the victim informed the duty officer about his daughter's injuries and her admission to Bangur Hospital. The matter was diarized under Toligang PSGD entry number 326, dated 31st December 1999 at about 2:40 p.m. Subsequently, Toligang PS case number
Toliganj police station. It is from Kolkata, Toliganj police station.
Toliganj PS case 405 of 1999, dated 31st December 1999, under Section 307 IPC was started against the accused appellant. The duty officer Siddhartha Banerjee, SI of Police PW 23, rushed to Bangalore Hospital and requisitioned the service of Dr. Sanjeev K.R. Saha, the RMO on duty at Bangalore Hospital, for recording the victim's statement. On demise of the victim, Section 302 IPC was added to the said PS case. The PS case was formally endorsed to SIS Banerjee for investigation. Since Tollygonj PS was bifurcated, the Charu Market PS was set up as per relevant government order. The Tollygonj case was transferred to the newly created Charu Market PS. On transfer of Tollygonj PS case number 405/1999 dated 31st December 1999 under section 307 IPC with an added section 302 IPC was renumbered as Charu Market PS case number 2 dated 6 January 2000 and 302 IPC. A formal FIR was accordingly drawn up. SI Biman Day of Charu Market PS was asked to conduct further investigation in this case. Charge sheet. In course of further investigation, the second IO tagged the record and Charu Market of Tollygonj and Charu Market PS case together as per the order of the ID
SDJM Alipur.
Okay. He arrested the appellant / accused.
These are all the
and
words
forwarded.
from especially from Kolkata. I had visited Kolkata High Court, so I know a little bit. I had two clients also. He arrested the appellant
/ accused and forwarded him to court. The SDGM on 6 January 2000. He also examined the relatives of the victim and other local people over the incident. He further seized some documents furnished by the father of the victim. After collection of alamets from the Tollygonj PS, he sent the same for FSL examination. The supplementary case diary of Jadavpur PS UD case number 1/2000 DT 1st January 2000 together with inquest report, PM and FSL report was collected. On completion of investigation, he submitted charge sheet under section 302 IPC under the appellant. Commitment and charge. On pursuit of relevant police papers and other connected materials on record, the case was committed to the court of ID Session Judge 24 Parganas, South Alipur, as per order dated 18th April 2000, passed in CGR 58/2000 by the ID SDJM Alipur. On transfer of the sessions case number SC 61/2000 ID Additional Sessions Judge 4th Court Alipur 24th Paragnas South framed the charge under 302 IPC against the accused appellant on 12th November 2010. He was asked to answer the following charge: that you on or about 31st December 1999 at about 10:30 hours at 92 Tollygonj Road, Kolkata 33 PS, Charu Market did commit murder by intentionally causing death of Reena and thereby committed an offense punishable under section 302 of the IPC and within the conscience of the Court of Sessions. On his pleading not guilty to the charge, he was put on trial. The trial. During trial, altogether 24 witnesses were examined on behalf of the prosecution in order to substantiate the charge of murder against the appellant. On conclusion of recording of evidence, the accused was examined under Section 313 CRPC. He pleaded innocence and false implication in order to substantiate the defense case that the victim sustained burn injuries because of the sudden burst of a stove. Sameer Sarkar, a friend of the appellant, was examined as DW1, save and accept defense suggestions to some of the witnesses regarding accidental fire. No document was filed on behalf of the defense in support of such plea of accidental fire. Upon consideration of the dying declaration Exhibit 1, FSL report and ocular evidence obscured through 24
Adduced through 24
PWS as also solitary defense witness. The learned trial court came to the finding and the appellant said that the appellant set fire to her wife by pouring kerosene oil and also by throwing a burning matchstick upon the wearing sari of the victim. He was of the opinion that the prosecution succeeded in establishing the charge under Section 302 IPC beyond reasonable doubt. The order of conviction and sentence was passed accordingly as indicated earlier, hence the present appeal. Appellant's contention. Appearing on behalf of the appellant, Mr. Basu scathingly assailed the judgment impugned on the ground that ID trial court passed an order of conviction basing solely on the dying declaration, which is tainted ex facie. According to him, reliance should not be placed upon the so-called dying declaration, which was not recorded in accordance with the principles laid down by the Apex Court. After observing all formalities, the presence of outsiders, namely the father of the victim and a neighbor at the time of recording of dying declaration, is bound to evoke suspicion in the mind of the court. There is every possibility of the victim being tutored to implicate her husband falsely. Neither Dr. Jada Bendra Sen, emergency doctor PW1, nor Dr. A.V. Datta, the senior surgeon under whom the patient was admitted, was approached for recording of the dying declaration. On the contrary, Dr. Sanjeev K.R. Saha, who never treated the victim medically at any point of time, was found present at the time of recording of the dying declaration by the police officer. There is nothing on record in the shape of any documentary evidence to indicate that the service of Dr. Saha, PW16, was requisitioned by the police officer, PW23, through the superintendent of MR Bangur Hospital for recording dying declaration of the victim. Admittedly, the declarant was Bengali-speaking girl, while the mother tongue of the police officer and the doctor is also Bengali. However, curiously enough, the statement of the victim was recorded in English. The conduct of the police officer, as also the doctor, in his opinion, raises doubt that the genuineness of the dying declaration in question.
Wait, Palam. Very well read. Now, this is one judgment which Palomi was reading. If you see, it is actually divided very properly. I'll request Vandana to put this in group. In the first paragraph, which is not read to us, what is actually the punishment and all that is given. In para 2, what was the background of the girl was given, that is the victim girl. Para 3 also same 4. Now registration of police case. See how it is divided properly to make you understand. One of the well written judgment. Next is then charge sheet is filed. The first registration of police case, then charge sheet is filed, then commitment and charge framing. This LD is learned, right? Learned session judge. for everybody here. To the court of learned session judge, 24 paraganas. If you go to Kolkata, you will be knowing all these places. I've been to Kolkata High Court, so I'm aware. This is about the trial. This is appellant's contention. This is admissibility of the dying declaration. How dying declaration? If you see, there is one point which is taken out here, that two doctors who has treated the victim girl was not called for recording of the dying declaration. A doctor, Sanjeev Kumar, who has not treated, Sanjeev Kumar Saha, was present at the time of recording dying declaration, which was very fishy. That is the point taken up by the defense lawyer. Appreciation of dying declaration is a very important judgment which Palomi read today. Try to read it, because we will not be having any more sessions now. Form of dying declaration. Then contents of dying declaration. Everything is given. One of the very good judgment. And in detail, importance of dying declaration. So if you have read this judgment, it will be very easy for you to run the trial of your client. Defense case क्या था उसमें, सीजर लिस्ट क्या क्या सीज किया गया था from the scene of offense. Okay, examination under section 313, statement of the accused. Then prosecution witness not supporting the prosecution case. Post-mortem report. You try to understand, this is one of the very important judgment. What are the findings by the court? Read it tonight if possible. What is the decision given? What is the result? Appeal is dismissed. What are the directions given? It is one of the very good judgment and very well written. Palomi was lucky to read it. Okay, good. Now next we go to our regular session of legal vocabulary. I have prepared these words. Somebody was asking me to email them. I would request other way around. आप लोग बना दो और थोड़ा words मुझे भेजो. Let me check. Now this first word we are going to rough weather. Every relationship faces rough weather, but it survives only if you are honest. There is another word, mirth and merriment. This is like about the way happily. The petitioner was looking for life full of mirth and merriment with the respondent. You can use these words when you draft a divorce petition. Magnanimous nature. Magnanimous मतलब दयालु या बहुत बड़प्पन बताना, माफी दे देना, बड़प्पन बता के. The defendant took advantage of the magnanimous nature of the plaintiff. उदारता, वो बहुत उदार था. And duped him of a huge amount. जनरस आदमी को डुबा दिया उन्होंने. Because उसका नेचर बहुत बड़प्पन का था. Normally we use the court to show magnanimity. And when we are tendering an apology, जब हम लोग apology court से माफी मांगते हैं, बोलते court में show the magnanimity, ऐसे बोलते हैं. Laudable attitude, everybody know meaning of the laudable, जिसमें प्रशंसा की जाती है. The attitude of the litigant is far from laudable, as it does not want to settle, even though it has no merit in the case. Case उनका बेकार है, फिर भी वो settle नहीं करना चाहते. मतलब क्या उनमें अप्रिशिएट करें. नॉट ओनली नेगेटिव में मैंने यूज किया है, नॉट ओनली बट ऑल्सो इज वेरी सिंपल वर्ड अगेन. द पिटिशनर वाज नॉट ओनली क्रूअल बट ऑल्सो फुल ऑफ हेट्रेड अगेंस्ट हिज ओन फैमिली. 46 next word is abundant care. The physical fitness of the deponent is required to be checked with abundant care and caution, as her statement is likely to be used in the court as a piece of testimony. अगर किसी का आप स्टेटमेंट कोर्ट में यूज करें तो उसका फिजिकल फिटनेस देखना भी जरूरी है. क्योंकि पता नहीं उन्होंने कौन से स्टेट ऑफ माइंड में या स्टेट ऑफ फिजिकल हेल्थ के समय दिया है. पॉइंट ऑफ नो रिटर्न. We have to take care of the environment before we go to the point of no return, harm our own ecology. How we use plastic and all that. So, there is no point of return. एक बार मतलब आपके हाथ से सिचुएशन चली गई तो चली गई. So better we take our situation on hands. Divergence, that is different. There is a divergence of opinion in filing divorce or maintenance cases. क्या फाइल करो, डिवोर्स फाइल करो या मेंटेनेंस. Illicit intimacy, गलत रिलेशन. The false charge of illicit intimacy is the highest level of cruelty against the respondent level by the petitioner. अगर गलत चार्ज लगा है illicit intimacy का तो highest level of cruelty है. Futile attempt, ऐसा attempt जिसका कोई fruitless exercise है. It would be absolutely futile exercise to burden upon the litigant and the parties to the section 482 application to face the trial, and that too which have no logical conclusion. And it would be absolutely an exercise of futility. See, this is used in one very good judgment. So it is a fruitless exercise or futile exercise, you can say like this. So this was all about, we have completed 28 days. I'm opening the